एसी कम 25 कर दियो तो एम्बिएंट टेम्परेचर 25 ओके सो टेस्ट वीकली टेस्ट में डिस्कशन करिवा ओके ऑल ऑफ यू हैव गिवन द टेस्ट जोने क्लासरूम स्टूडेंट्स एटीएससी देले ऑनलाइन स्टूडेंट्स तो आपन वीकली टेस्ट फोल्डर को जिबे से वीकली टेस्ट फोल्डर रे ओके सेठी आपन पाई जिबे इन द वीकली टेस्ट फोल्डर सो लास्ट वीक रे मैं देखथिलु सेक्शन 1 to 20 ओके बीएसए रा तो आज देखिबा 21 रु ओके 40 सो पाखरे प्रथमे बेयर एक्ट कोटे रखंतु ओके तो अपन रेफर करिया पे सुविधा हो ठीक अछि हैव ए बेयर एक्ट आउ तापरे वी विल डिस्कस द क्वेश्चंस वन बाय वन ऑनलाइन जो मन टेस्ट होचंती सबमिट कला परे आपनकर मार्क्स और रैंक आछिबो तापरे तार जो डिस्क्रिप्शन अछि किबा जो डिटेल सॉल्यूशन अछि सेठी गले आपण एक्सप्लेनेशन टा भी पाई जेबे ओके ऑनलाइन देले भी ओएमआर रे दवा पे चेष्टा करंतु माने ऑनलाइन क्वेश्चन देखंतु ओएमआर रे किंतु मार्किंग करंतु केना एग्जाम ता तो हमर ऑफलाइन ओके आ ओएमआर रे टिके अधिक टाइम लेके लिखे माने मार्किंग करिया पे कोनटा फिर ना मत कर वन करे ना
उनका जो टेस्ट से करने में ऑफर चलेगा कि नहीं जैसे चल
Okay, so online students, look at your screen. तो क्वेश्चन जोड़ा ओके से उठो अपना रेफर करंतु classroom students ଆପଣଙ୍କର ଯୋଉଟା ଦିଆ ହେଇଛି copy ସେଥିରେ we can go through that. So question 1 को ଆସନ୍ତୁ. Okay. So question 1 ହେଲା in what context are admissions considered relevant in what context are admissions considered relevant in civil cases under section 21 of BSA? Okay. So when made under coercion, when made under coercion, when made voluntarily during the course of the proceedings, when made during informal conversations outside the court, when made under oath only. कौन होगा आंसर? कौन लिखे हैं आपने? B. हाँ, when made voluntarily during the course of proceeding. सेटा ठीक आंसर होगा. Okay, ताको रेफर करिया पे you can refer to your okay जो बेयर एक्ट अपन यूज करछंदी सेतरे रेफर नहीं सेमती करो सेमती के एटा अपन ऑनलाइन स्टूडेंट्स तो अपन डायरेक्ट सबमिट करिवे आसीयो. ऑफलाइन स्टूडेंट्स ओएमआर रे मार्क करछंदी अपन ऐप रे अछि टेस्टटा तो टेस्टटा देबे आफ्टर द क्लास जस्ट मार्क एवरीथिंग. अपन एठी जा मार्क करछन सेठी मार्क करी सबमिट कर देबे तो से रैंक भी दे दो आपनकर मार्क्स भी दे देबो नेगेटिव सब होई जो एठी अपन डबल काम करिया कोन दरकार पुनी अपन केतेटा ठीक भूल पुनी सब अपन बात करथे. ठीक अछि तो बुझ परले तो क्लासरूम रे तले अपन प्रीलिम्स टेस्ट दोचंदी तो फर्स्ट टेस्ट दे देबे ओएमआर पे हे गला एटा तापरे सेटा ऑलरेडी अपलोडेड हे जेथिबो अपन ऐप को तो ऐप रे जेंकी जस्ट खाली कॉपी कर देबे जहा जहा आंसर दैचंदी से सेतरे ओके करिकि सबमिट कर देबे. सो अपन को रैंक भी आसी गला केना अधिका पिला ऑनलाइन रे दोचंदी. ओके सो यू गेट योर रैंक यू गेट योर मार्क्स नेगेटिव एक्यूरेसी रिकॉल सब आपनकर पूरा एनालिसिस आछियो. ओके anyway now come to question 2. Why are confessions made under inducement, threat, coercion or promise considered irrelevant in criminal proceedings under section 22? They are always false. They are made without presence of a lawyer. They are considered involuntary and unreliable. They are made outside the court. So C hobo eta they are considered involuntary and unreliable. Okay, so आमे देखिचु foundation of any kind of confession is voluntariness. Okay, कोनोसी प्रकार रो coercion, threat, inducement, promise, okay, duress से गुडा जति रहिला confession रे ताले सेटा inadmissible हबो. किंतु admissions रो आमे देखिलु कोन coerced admission okay admissible हे पर. ठीक है admission ता coerce करी कि जति नै होछि. Okay, जोटा कि admission और confession रो difference रे हमें पढ़िथिलु. Now so C हला answer 2 रो. Now come to question 3. Under section 23, why are confessions to police officers inadmissible in court? We know that it is inadmissible. कोन तारो main कारण होई पारे? They are always fabricated. They are made without a magistrate's supervision. They are considered involuntary. They are made under influence of law enforcement. So they are considered involuntary. Okay, just we जोटा discuss कलु confession रो admissibility रो bedrock हैला voluntariness. Okay, voluntariness जदि नथिबो ताले सेटा से confession टाको admissible हबनी court रे. Okay, now come to question 4. Section 24 states that a proved confession can affect which of the following? Only the person who made the confession, co-accused individuals who are jointly tried for the same offense, any individual mentioned in the confession, the entire community where crime occurred. So B hobo, okay, that is co-accused individuals who are jointly tried for the same offense. Seta important. जॉइंटली ट्राई माने तांको ऊपर केस टा चलतिबा दरकार जोटा कि सेही सेक्शन रो इलस्ट्रेशन रे जोटा गोटे देछि कि ए रो मर्डर करचंती बी आउ सी किंतु केस चलीछि केवल बी ऊपर बी इज बीइंग ट्राइड बट देयर इज एविडेंस दैट सी हैज आल्सो मर्डर्ड बी सी मिसी की मर्डर करचंती ए रो ओके किंतु केस चलीछि मर्डर रो केवल बी ऊपर सी ऊपर चलनी से थरे सी गोटे कन्फेशन देला कि बी आउ मु मिसी की ए को मारिछु ताले से कन्फेशन रो जीरो वैल्यू इन द सेंस एज अ कन्फेशन सेटा हबन काहे ना सेटा थर्ड पार्टी कोच ओके काहे ना सी ऊपर सी को अक्यूज नो ता ऊपर केस चलिन ठीक अछि तो ऑल्दो एविडेंस अछि कि से भी मर्डर करछ ओके सो eta question 4 so B is the answer co-accused individuals who are jointly tried okay for the same offense right now come to question 5 under section 25 why are admissions not considered conclusive proof but may still be relevant because they are made under duress because they can stop stop the admitting party from denying the fact okay estoppel jota ame dekhthilo then because they are often contradictory because they require corroboration from multiple sources so it is directly seti barract re lekha hichi ki exception ta kono jodi seta estoppel hisab re kam kortibo so B will be the answer because they can still stop the admitting party from denying the fact okay so eta hala 5 now come to question 6 the concept of special means of knowledge, as mentioned in section 26E of the BSA, in context of statement about relationships, signifies that the person making the statement, so eta kono, ame 26A ta dekhilu, okay, kon thila, dying declaration, semti 26E re se kon kochi, ki jara, okay, kichi gote relation ra, gote relationship pe thibo, au tara special knowledge, okay, in মানে the কম কত ইনসাইডার্স নলেজ তার থিব তো সেটা বি রেলেভেন্ট হবো ওকে তো সেইথরে সে কହୁଛି স্পেশাল মিন্স অফ নলেজ অর্থ কোন what do you mean by special means of knowledge okay so possess first an information about the specific relation in question acquired through direct observation or interaction was related to one or more of the persons whose relationship is in dispute, creating a presumption of knowledge, had access to official records or documents pertaining to the relationship, providing a reliable source of information, was generally aware of family matters and gossip, making their statement potentially relevant but not necessarily conclusive. So, A will be the answer, 26E rep. Possessed first-hand information about the specific relationship in question, acquired through direct observation or interaction. तांको relationship जोगु तांको पाखरे एमिति किछि information अछि जोटा special. Okay, अन्य मानको पाखे से information नाही. Okay, so that would be relevant. तो सेटा okay, 6th row answer A. Now come to 7. According to section 27, a statement made by deceased person can be considered relevant in which of the following cases? Okay, when it pertains to a trivial matter, when it was made in casual conversations, okay. Third, when it relates to the cause of their death or when it was overheard by a stranger. So C hoba answer. Okay, when it relates to the cause of their death, that will be the answer. Next, question 8 ko. The phrase full understanding of nature and effect of the statement in section 33 of BSA implies that when admitting part of a larger statement, the court should consider the literal meaning of the words in statement irrespective of surrounding context, the subjective intent of the person who made the statement, even if it contradicts the plain language, the overall context, including the preceding and subsequent parts of conversation or document, to accurately interpret the statement's meaning and implications, or D, the potential impact of statement on the outcome of the case, regardless of its actual content or meaning. Okay, so C would be the answer. The overall context, including the preceding and subsequent parts of the conversation or document, to accurately interpret the statement's meaning and implication. Okay, full understanding of nature and effect of statement. So C is the answer for question 8. Now come to question 9. Excuse me. Section 28 specifies the statements made under which of the following circumstances are relevant. Okay. During police interrogation, during a court order, during the regular course of business, or under duress. So during regular course of business. Okay. C would be the answer. Question 9. Now come to question 10. According to section 28, entries in books of accounts are relevant under which condition? They are made by persons regardless of their position. They are regularly kept in course of business. They are written in ink. They are witnessed by a third party. So B is the answer. They are regularly kept in course of business. Okay. Question 10. Then come to question 11. What does section 29 state about entities in public records or electronic records? They are always inadmissible. They are relevant if made in the performance of official duty. They must be corroborated by oral evidence, or they are only relevant if made in ink. Okay, so B would be the answer. They are relevant if made in the performance of official duty. 11 ro answer is B. Now come to question 12. Which statements are relevant under section 30? Statements made by cartographers in private maps, statements in official maps, charts and plans, statements in maps made for educational purposes, or statements in unofficial surveys. Okay, so B will be the answer. Statements in official maps, charts and plans. Next, come to question 13. Under section 31, statements regarding facts of public nature are relevant if contained in which of the following? Private letters, official acts or notifications, unpublished manuscripts, or personal diaries. B, official acts or notifications. Okay, 13 ro B hobo answer. Now come to question 14. According to section 32, statements about laws are relevant if they are found in which of the following sources? Personal opinions of lawyers, law books including electronic or digital format, newspapers, social media posts. So B will be the answer. Law books including electronic or digital format. Question 15 ka asantu. Section 33 addresses the proof of which portion of the statement? The entire statement, only the relevant parts, the introduction and conclusion, the parts that favor the prosecution. B will be the answer. Only the relevant parts. Okay. Then 16 question. Under section 33, when a statement is a part of a large body of evidence, which part must be proved? Okay, so it 15 sange almost related hi hochi. The entire conversation or document, only the relevant and necessary parts, the first and last parts, the parts identified by court. So B will be the answer. Only the relevant and necessary parts. 16 ro B hobo answer. Now come to question 17. According to section 33, in which instances are judgments of court relevant? Okay, so always regardless of context, when they directly relate to the matter in question, when cited by a reputable lawyer, when they are recent. B will be answer. When they directly relate to the matter in question. Okay, now come to question number 18. Section 34 deals with relevancy of previous judgments in which context? To provide general legal principles, to bar a second suit or trial for the same matter, to show the character of a witness, to provide background information. So B again. Okay, that is to bar a second suit or trial for the same matter. That is question 18. Now come to question 19. Under section 35, which type of judgments are considered relevant? Judgment in civil cases, judgment in probate, matrimonial, admiralty and insolvency jurisdictions, judgments in criminal cases, judgments in administrative decision. Okay. Yes, so judgment in probate, matrimonial, admiralty and insolvency jurisdictions. ଆମେ ଏଇ ଚାରିଟା ଟର୍ମ ଟା ଟିକେ define करथुलु ता विषय बुझिदिलु. Anyone who can tell me first कोन probate माने कोन?
होची हमें हमर जो will जो मैटर गुडाक डिसीजन लिया जाए जो कोर्ट रे that could considered as the probate court.
Yes, that is the probate court. Probate means a proceeding in which the will, okay, the will टाको आपण execute करछन. Either first देखुछन will टा valid अछि कि invalid अछि. जदि will टा valid अछि ताले will टा execute होछि. Okay, that is a probate proceeding. तापर से देला second term जोटा, that is your matrimonial, that you understand, related to marriage and all. तापर असला admiralty. Okay, admiralty माने कोन?
आर्मी जो एडमिरल जो पोजीशन होची सेमानकर जो मैटर
Maritime laws, naval related to navy. Okay, navy माने in the sense कि maritime laws. Okay, for so that is known as admiralty laws. So maritime laws. Okay, navigation rights. Okay, territorial rights. एगुड़ा सब admiralty laws ताको कहते. Means these are laws related to maritime subjects. Okay, आउ तापर आसिला insolvency माने गोटे लोकर कि गोटे कंपनी रो गोटे एंटिटी रो तार डेब्ट्स करिका दबा पई. Okay, means he is basically, okay, तार financial position कोन अछि. More technically, is he able to, okay, is in a financial position to pay off his debts. जहाँ तक ऊपर loans करिका अछि सेटा से पे करि परिबे कि नहीं. Okay, so next then come to next question. That is कितने questions are? 20. Question 20. So come to question 20. Section 36 discusses the relevancy of which judicial documents: judgments, orders or decrees in administrative cases, judgments, order or decrees other than those in section 35, only criminal case judgments, only civil case judgments. B, judgments, orders or decrees other than those in section 35. Okay, now come to 21. According to section 38, which of the following can be proved? The authenticity of a judgment, fraud or collusion is obtaining a judgment, the popularity of the judge, the public opinion about the case. So B, fraud or collusion in obtaining a judgment. Okay. ଆମେ ଦେଖିଥିଲୁ କୋଉ ଗ୍ରାଉଣ୍ଡସ୍ ରେ ତାକୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିପାରିବେ fraud collusion ଯଦି ହେଇଥିବ କିମ୍ବା ଆଉ ଗୋଟେ ଟର୍ମ ଆମେ ଯୋଉଟା ଆମେ ଡିସ୍କସ କରୁଥିଲୁ କଣ incompetence of the court, and we had discussed what is the actual meaning of the term incompetence. Okay, incompetence does not mean something related to efficiency. Incompetence mainly means, okay, is related to your subject matter jurisdiction. Because gote you know court ro tar jurisdiction nahi, mainly subject matter jurisdiction nahi, au se city jodi, okay, it goes into that case and decides the case, right? CPC रे हमें देखी चुकी jurisdiction नथिले भी except subject matter, बाकी jurisdiction नथिले भी, okay, ताले आपनकर decree टा nullity हुएनी, ठीक है, सेटा irregular exercise of jurisdiction हुए, okay, that you will study in CPC. But subject matter jurisdiction रे यदि भूल हुए, normally it will be a nullity, okay, से जिनसेटा से, but it is सेटा हमें evidence laws हिसाब से सेटा देखो, okay. So fraud or collusion in obtaining a judgment. Okay, so 38, section 38 related, question 21. Now come to question 22. Under section 39 of the opinion of third person are relevant in which context? In matters of public interest, when they have direct knowledge of the facts, in matters requiring specialized knowledge, where they are highly regarded in society. When they are highly regarded in society. So C is the answer. Okay, eta hela amaro expert opinion ro, right? Ta bisare kochi 39 in matters requiring specialized knowledge. Okay, if matter does not require specialized knowledge, then expert opinion ro relevance kichi nahi. Okay, general jinso jodi achi sethare actually expert opinion kichi darkar nahi. Common sense re seta jana padi jauchi. Sethi धरंतु prosecution expert नहीं आस, okay, expert opinion ki expert witness ko anchi to seta relevant hobo nahi, it will be irrelevant because expert okay knowledge is not required. That's the next question to achi 23 ko asantu. Section 39 pertains to relevancy of just a minute online students ko enter kar diye. Section 39 pertains to the relevancy of opinions from which individuals, eyewitness, lay persons, expert in particular field or journalist. So C, experts in particular fields. So repeat kochi question ta. According to section 40, what kind of facts are relevant to the opinion of experts? Okay, irrelevant details, facts that support or contradict the expert opinion, personal beliefs of expert or public opinion. So B will be the answer. Facts that support or contradict the expert opinion. हमें देखते लो facts B for Bravo. ठीक है, जब मैं generally mnemonics use करूँ कौनो ABCD by Alpha, Bravo, Charlie, Delta. ठीक है जी, केबे केबे कहला वाले B और D एका बड़े सुखा जाए. Okay, तो that is the reason एडा मैं use करूँगा. तो सेत्र कौन देखते लो 40 रे कि normally जो fact उड़ा normally irrelevant. ओके सेगुडा रेलेवेंट केतोळे हे जाउची जदी एक्सपर्ट ओपिनियन गोटे दिया हिची ओके आउ सेही पर्टिकुलर फैक्टटा एक्सपर्ट ओपिनियन को कॉन्ट्राडिक्ट करूची कि कॉरबोरेट करूची ताहले से रेलेवेंट हे जाउची जदी एक्सपर्ट ओपिनियन ता काटी देबे ताहले से फैक्टटा इररिलेवेंट ही रहइबो बट इन दिस केस इट बिकम्स रेलेवेंट ओके दैट इज व्हाट सेक्शन 40 इज सेइंग सो दैट इज facts that support or contradict the expert's opinion. Now 25%. Under section 40, in which situation is opinion of an expert considered irrelevant? Okay, Joda just when the expert has conflict of interest, when the expert is not available to testify, when the matter does not require specialized knowledge, when the expert's opinion is uncorroborated. Okay, so irrelevant ketevale hobo when the matter does not require specialized knowledge. Okay, now come to 26. The primary purpose of section 21 of BSA, which addresses admissions in civil cases, is to prevent parties from admitting facts they later regret, protect confidential or privileged communication, uphold the integrity of agreements between parties regarding admissibility of evidence, simplify the process of proving facts in civil cases. C will be correct. Okay. So, uphold the integrity of agreements between parties regarding the admissibility of evidence. तामाने parties माने जदि आगुरु agree करचंदी कि हमें एई जिंसटा को evidence हिसाब रे कोर्ट रे दबानी ताले सेटा कोर्ट को evidence हिसाब रे आसीबो. Okay, civil cases.
Insignificance, no admission is admissible. तो civil case admission ही दरकार हो. किंतु जब दिवे जा कॉन्स्टिट्यूशन पड़ी से कुछ तक प्री एग्रीमेंट है जी ताले सेटा हबनी जदि माने जॉइंट एग्रीमेंट एविडेंस होची सेकंड को तो चेंज इन सर्कमस्टेंसेस से जति क्वेश्चन ऑफ लॉ रे से बोल सेकंड है माने नहीं देखो आज सेटा ही क्लियर है उसे बड़े भावली कि हमर सिविल केस रे एडमिशन की आवश्यकता दरकार.
नहीं से कोन कोची कि जति दीटा पार्टी सिविल केस रे दीटा पार्टी से माने गोटे एग्रीमेंट करचंदी एई पर्टिकुलर जिंसटा को हम एविडेंस हिसाब रे प्रेजेंट करबानी कोर्ट रे. ओके ताले सेटा से माने मानिबे व्हेन द कोर्ट इज informed of that court will not take that as evidence. ठीक अछि सेही जिंसटा से पहुंच. Now come to question 27. So 26 रा आंसर हैला C. Okay, now come to 27. The underlying principle behind section 22 of BSA 2023 concerning confessions caused by inducement, threat or promise is to protect the accused for self-incrimination, ensure the reliability and voluntariness of confessions, prevent the misuse of authority by persons in power, or all of these. Okay,
Option B sir, ensure the reliability and voluntariness of the confession.
A और C होबनी
सब जगह तो माने लागू छै नॉन बी ऑप्शन सही एटा ही
all of these होबो. Okay, देखंतु गोटे गोटे के देखिबा confessions caused by inducement, threat, promise. Okay, आ गोटे टर्म कौन मिस कर देला इंड्यूसमेंट देला थ्रेट देला प्रॉमिस देला चारटा थिला ना चारटा देखिथिलो हमें आ कोन थिला हाँ सेटा ऑल हबो नै मु पचरची एठी तीनटा जिंस देला इंड्यूसमेंट देला थ्रेट देला हां कोर्शन ओके सो एई चारटा ऑब्वियसली हेले तो आपनकर राइट कन्फेशन हबनी किंतु जो कन्फेशन हबनी बोली हमें कहूचु इट प्रोटेक्ट्स व्हिच ऑफ द राइट्स तो फर्स्ट आसिला प्रोटेक्ट द अक्यूज्ड फ्रॉम सेल्फ इंक्रिमिनेशन ओके निजो अगेंस्ट रे आपण साक्षी देबे कि किछि एविडेंस देबे दैट इज वन ऑफ द मोस्ट ओके दैट प्रोटेक्शन अगेंस्ट दैट इज अ फंडामेंटल राइट आल्सो ओके जण को आपण फोर्स करि परिबेनी सेल्फ इंक्रिमिनेशन पे ठीक अछि तो सेटा प्रोटेक्ट कला एंश्योर द रिलायबिलिटी एंड वॉलंटरीनेस ऑफ कन्फेशंस ठीक अछि कि से वॉलंटरीली कन्फेस करूची ओके सो दैट द कन्फेशन विल बी रिलायबल आउ थर्ड भी हबो काहे ना पुलिस गरिका जदी ताको फोर्स कले कि एडमिनिस्ट्रेशन फोर्स कला कि जदी तुमे दबने हम या कर देबो राइट सो ऑल ऑफ दिस विल बी ट्रू हां डी डज नहीं दैट इज करेक्ट सबले एमसीक्यू रे मन रखिबे आस्ते आस्ते एबे तो ओजेएस एक्चुअली से लेवल को जाइनी किंतु आगु जीव निश्चित इन द सिविल सर्विस रे पड़े सो ऑल द ऑप्शंस आर वेरी क्लोज एंड कंफ्यूजिंग आपण यदि ऑप्शन चारटा पढिबे आपण लागि तो एका जिंस चारि थरो खाली भाषा बदली की लिखा हिची ओके तेनु जदी आपण केतेबेले भी लागिवो मोर देन वन ऑप्शंस आर करेक्ट सो यू हैव टू गो फॉर द मोस्ट एप्रोप्रिएट ऑप्शन जेतो हमर गोटे ही ऑप्शन अछि किबा जदी आपण देखिबे ऑल ऑफ द अबव कि ऑल ऑफ दिस हबे ताले ठीक अछि नले यदि गोटे कहिची ताले ऑब्वियसली यू हैव टू चूज द मोस्ट एप्रोप्रिएट वन आपण को जोटा लागुची प्रायोरिटी बेसिस रे सबुठु जोटा हबारो चांसेस अछि आंसर सेटा को मार्क करिवे ओके नाउ कम टू क्वेश्चन 28 the provision to section 23(2) of BSA which allows for proof of information leading to discovery of a fact even if obtained from a confession to police officer is based on the principle of तेणु एबे एटा डायरेक्ट क्वेश्चन नो ओके एटा कोन ना हम टेक्स्ट बुक रे पढले हम प्रिंसिपल्स रो बाहर करबा प्रथम जो 10-15टा क्वेश्चन की 20टा क्वेश्चन हम देखलु सेटा डायरेक्ट टाइप रो थिला एबे एडा मोर एनालिटिकल क्वेश्चंस अछि ओके based on the principle of necessity public interest balancing the rights of the accused with the need for effective investigation kimba judicial discretion C is correct balancing the rights of the accused okay with the need for effective investigation
जेमति कि हमर 23 तो कोछि ना सिर्फ पुलिस आगे कन्फेशन माने कन्फेशन ता एडमिशन होबनी तो नेसेसिटी से कुछ आवश्यक पड़ोनी पब्लिक इंटरेस्ट रे एठी तो गोटे एक्टिविटी नहीं कोला से तारो कन स्टेटमेंट दो पब्लिक इंटरेस्ट भी आसो और जुडिशियल डिस्क्रिप्शन पुलिस वगैरह कोन भी आसो
ओके सी होबो तार आंसर जदी डायरेक्ट आंसर जणा नै एलिमिनेट भी करिवे अपन ओके एलिमिनेशन मेथड now 29 के असंतो section 24 of BSA dealing with consideration of proved confessions affecting multiple accused reflects the principle that confessions are inherently unreliable and should be used with caution. The court has the discretion to assess the impact of a confession on a co-accused. A confession made by one accused cannot be used against other. Joint trials are inherently unfair to the accused. B will be the correct answer. The court has the discretion to assess the impact of a confession on co-accused. Okay, court koro discretion seta rochi. Now come to question 30. The essence of section 25 of BSA, which states that admissions are not conclusive proof, is to emphasize the rebuttal nature of admissions, allow parties to retract their admissions, prevent admissions from being used as evidence, limit the evidentiary value of admissions in civil cases. Yes, admissions can be rebutted. Admissions can be rebutted. Okay, they are not conclusive proof. Right. Are they substantial proof? Admission substantial proof ki no? substantial proof कि नुह आपण आंसर देथिले थरे जो दिन पढाइतला ता नेक्स्ट डे substantial proof कि नुह हाँ ऑनलाइन स्टूडेंट के कोन कहउचंदी
Sir, admission substantial. Sir.
admission substantial proof but not conclusive proof okay सेटा जो माने टेक्स्ट बुक रु पढिबाटा बेस्ट
भागीरथी वर्सेस भागीरथी रो केस नहीं थिला से कहितला कि हम सुप्रीम कोर्ट हेल्प करबिटा कि हमर एडमिशन ता सब्सटेंशियल प्रूफ बट नॉट कंक्लूसिव
हेला जदी भी डायरेक्टली आपण ताको पढु नांती ताहले जो कमेंट्स देची बेयर एक्ट रे सबले माने पूरा जो गवर्नमेंट ऑफ इंडिया रो वेबसाइट रे होती से बेयर एक्ट न करी कि आपण बेयर एक्ट विथ कमेंट्स आनिबे तो से कमेंट्स रे एटा देची ओके किबा टेक्स्ट बुक रे भी देची पॉइंट्स okay it is substantive okay but not conclusive hela anyway come back to the questions kete number thilo 30 the essence of section a emphasize the rebuttal nature of admissions now come to 31 the rationale behind section 26 of BSA which deals with statements by persons who cannot be called as witness is to tara objective kon rational mane kon ta objective kon aim kon ensure that relevant evidence is not lost due to unavailability of person who made the statement expand the scope of hearsay evidence allow for admission of any statement made by deceased person simplify the process of proving facts in court okay so a hobo ensure that relevant evidence is not lost due to unavailability of the person who has made the statement. Okay. So A is the answer for 31. Now come to 32. The key distinction between between statements admissible under section 26A dying declaration and other statements under section 26 B C D okay so is that dying declarations are considered more reliable other statements require corroboration dying declarations are admissible regardless of expectation of death other statements are admissible only in civil cases C eta hela one of the basic premises or one of the basic features of dying declaration that expectation of death is not needed okay तो जोडा हमें डिस्कस करथलु ओडिसा रिलेटेड केस ता ओके पकाला स्वामी राइट तो सेतरे हमें देखलु कोन ताकू चिट्ठी आसिला तुमारो बकाया सैलरी आसी कि नहीं जाओ ओके सो ही वाज एक्सपेक्टिंग ही विल गेट हिज सैलरी ते मते मारी देबे बोली तांकर माने किछि ही हैड नो you know awareness okay ki knowledge that there is a chance that he will be killed there tak mariya pai dakuchandi okay so he showed the letter to his wife the next day gale and you know tapar tangara dead body midla trunk re right so next so C is the answer okay 32 by C is the answer dying declarations are admissible regardless of expectation of death now come to 33 The primary objective of section 27 of BSA, which pertains to relevance of evidence given in previous proceeding, is to prevent witness from changing their statement, avoid unnecessary repetition of evidence, ensure consistency in judicial proceedings, or preserve the testimony of witnesses who are unavailable in subsequent proceedings. D will be the answer. Now, eta D ta pai kaam kore in the same case and in other separate case also. Related to that matter okay suppose mu witness achi mu court re jain kahichi ki mu e lokota ku dekhichi okay gote particular act karibar to dharantu se then I am not available okay suppose tapare mu sannyas ne goli okay paleli 30 40 varsh pai so barshe pore same okay subject ku nei ki same matter ku nei ki au gote case hela ओके तो मोर ए जो एविडेंस रा सेठी यूज करा जाई पारिबो आउ डिफरेंट स्टेजेस ऑफ द सेम केस रे ऑब्वियसली यूज हे पारिबो ओके सो इन बोथ केसेस इट विल बी यूज्ड इन द सेम केस एंड इन सब्सिक्वेंट केसेस वेयर ओके द इफ द मैटर इज द सेम ओके So सेटा हैला 33 तापर 34 को असंदु D is the answer. Okay, 33 रो. Then come to 34. The condition to section 27 that the adverse party is the first proceeding had the right and opportunity to cross-examine is crucial because it ensures fairness and prevents the admission, okay, or untested evidence, protects the right of the accused in criminal cases, upholds the principle of natural justice, all of the above. All of the above. Okay. ସେଥିରେ ଗୋଟେ ଜିନିଷ ମୁଁ କହିଥିଲି ଇମ୍ପୋର୍ଟାଣ୍ଟ ଜିନିଷଟା କଣ opportunity ଟା ପ୍ରୋଭାଇଡ ହେଇଥିବା ଦରକାର actual cross examination ନ ହେଇଥିଲେ ବି ଚଳିବ suppose the other party was afforded the opportunity ତାଙ୍କୁ ଦିଆ ହେଲା ଆପଣ cross examination କରନ୍ତୁ ସେମାନେ କଲେନି ମନା କରିଦେଲେ ଆମେ କରିବୁନି okay that means they got the opportunity ତ ପରେ ଆଉ ସେଇଆ କହିହବନି କି ଆମକୁ ସେତେବେଳେ cross examination ଆମେ କରିପାରିଲୁନି ଯଦି opportunity ଦେଇ ନଥିବ କୋର୍ଟ okay ତାହେଲେ ସେଟା ଆଉ subsequently same okay ସେ ଲୋକର ଯାହା evidence ଟା okay ଯେ ଏବେ ଆସି ପରିବନି ଆଉ ସେଟା यूज करी हबन opportunity is the main thing not the actual cross examination हैला तो এই पॉइंट भी मन रखिबे that opportunity fair opportunity must have been given actual cross examination ही कि नहीं does not matter okay so all of the above 34 next 35 को जानतो section 28 of BSA which deals with relevancy of entries in books of account is based on presumption that business records are generally reliable. Entries made in regular course of business are accurate. Account books are conclusive proof of liability. D hela both A and B. Yes, both A and B. Okay, they are not conclusive proof. Okay, jota amar dekhichu kono account book ro jaha bhi regular transaction re regular process of business re jaha taku maintain kara hichi taku corroborative evidence darkar seta in itself it cannot okay prove liability right so it requires corroborative evidence now come to 36 so 35 ro D hela answer now come to 36 the requirement in section 28 that entries in books of account be regularly kept in course of business is intended to exclude casual or personal records, ensure that records are maintained systematically and consistently, prevent the fabrication of evidence. Fabrication means michwacha koiki taku bhulbal manipulate kariba. All of the above. So all of the above habo. Okay, 36D habo. Then come to 37. The main purpose of section 29 of BSA 2023, which addresses the relevancy of entries in public records, is to simplify the proof of facts of a public nature, recognize the reliability of official records, reduce the burden on public servants to testify in court. Okay, or all of the above. So it will be all of the above. Okay, 37 also will be D. Next, come to 38. The condition in section 29 that the entry be made by a public servant in the discharge of his official duty is essential because it ensures that the entry is within scope of public servant's authority, guarantees the accuracy and objectivity of the record, prevents the admission of personal opinion or biases, all of the above. It will be say all of the above, all are correct. Now come to 39. Section 30 of BSA, which deals with the relevancy of statements in maps, charts, and plans, is premised on the idea that when a basis published maps and charts are always accurate. Maps and plans made by the government are reliable sources of information. Statements in maps, charts, and plans are conclusive proof of facts they represent. Only maps and plans made for legal purposes are admissible in court. B. Maps and plans made by government are reliable sources of information. So 39 ro answer B hobo. Now come to 40. The distinction between maps or plans made for purposes of a cause and those made by the government or for public sale as highlighted in section 30 is significant because to the importance ta kon ach section 30 ro maps made for a cause are inadmissible. Government maps are automatically admissible in court. Maps made for public sale are less reliable. Only government maps can be used to prove facts in issue.
Option C, sir. Maps are made for public sale are less reliable.
The distinction between maps or plans made for purpose, okay, of a cause and those made by government or for public sale, okay, as highlighted in section 30 is significant. Kon pai significant hobo? Maps made for public sale are less reliable. Okay, public की जो मैप टा दिया होची सेटा कोन स्पेसिफिक ऑफ डिटेल मैप होबो की सपोज गोटे धरन तो आमे गोटे मैप एबे नबा मैप सुडा किए पब्लिश करे इंडिया रे सर्वेयर ओके और सर्वे ऑफ इंडिया सो सर्वे ऑफ इंडिया इज द ऑर्गेनाइजेशन दैट पब्लिशेस द मैप केतेटा मैप जोडा की आमे जोडा लगाउछु पॉलिटिकल मैप ऑफ इंडिया फिजिकल मैप ऑफ इंडिया पॉलिटिकल मैप ऑफ ओडिशा फिजिकल मैप ऑफ ओडिशा सपोज गोपालपुर ओके आमे गोपालपुर रो मैप जदी आनिबा तो अपन जानते गोपालपुर रे हमर एयर डिफेंस कॉलेज अछि से कोन पूरा एग्जैक्टली तार पूरा देथिबो एयर डिफेंस कॉलेज रो एई जगह रे एई बिल्डिंग अछि एई जगह रे एई बिल्डिंग अछि केबे नो यासरा पब्लिक सेल पे तो सेगुडा स्पेसिफिक मैप्स ओके सेगुडा ओपन नो सेगुडा यू नो क्लासिफाइड मैप्स ता कोन ना सीक्रेट मैप्स ओके जोटा पब्लिक रो यूज पे दिया होची सेटा ऑब्वियसली इट विल बी लेस रिलायबल ठीक अछि सो C is the answer. Map made for public sale are less reliable. That is why, what is the aim of public, the maps which are made for public sale? Overall idea. मु जदि मैप ऑफ इंडिया टा देखुची मु एया जानूची कि हां ओडिसा रो नेबरिंग स्टेट्स उडा एया ठीक अछि तो सेमति गोटे बेसिक ब्रॉड आइडिया मते मिलुची ओके बहुत ही स्पेसिफिक डिटेल्स सेथरे दिया जाई परिबन राइट तापरे नेक्स्ट द प्राइमरी purpose. So C is the answer for 40. Now come to 41. The primary purpose of section 31, which allows for use of recitals in acts or notifications or evidence, is to streamline the proof of facts of a public nature, give greater weight to official pronouncements, limit the scope of judicial review of legislative and executive action, replace the need for witness testimony in cases involving public matters. So A hoba answer to streamline the proof of facts of a public nature. Then question 42, the rationale behind section 32, which allows for the use of law books and reports of rulings, is to promote judicial reliance on precedent, enable the court to ascertain foreign law or legal principles, establish the hierarchy of legal sources, limit the court's discretion in interpreting the law. So B, enable the court to ascertain foreign law or legal principles. Okay, तो सेही हिसाब रे जोडा relevant books अछि हम कोन देखो authoritative books जोडा अछि सेउठु कोर्ट ओके तांकर डिसीजन टा कि ओपिनियन टा फॉर्म करि देन क्वेश्चन 43 के असंतु the principle behind section 33 which requires the presentation of sufficient context when introducing a statement as evidence is to prevent misinterpretation and ensure a fair understanding, limit the volume of evidence presented in court, prioritize written evidence over oral statements, shift the burden of proof to the party introducing the statement. So A will be the answer, prevent misinterpretations and ensure fair understanding. So 43 ro A will be the answer. Now come to 44. The doctrine of res judicata embodied in section 34 serves the purpose of promoting finality and preventing endless litigation, upholding the authority of prior judgments, ensuring consistency and predictability in legal outcomes, all of the above. So all of the above, okay, all of the above. Saboda is important. 44 or D. Now come to 45. The conclusive nature of judgments in probate, matrimonial, admiralty or insolvency matters, section 35, is justified by the specialized expertise of these courts, the need for certainty and stability in these areas of laws, the limited scope for appeal in these cases, the high stakes involved in these matters. So B would be the answer, the need for certainty and stability in these areas of laws. ଆମର ଯେତେବେଳେ initial questions ଥିଲା directly direct ଯାହା ଲେଖା ହେଇଛି ତା ଉପରେ ଯଦି question ପଡୁଛି ସେଟା ଟିକେ easy ରହୁଛି, କିନ୍ତୁ ଯଦି applicability ଉପରେ question ପଡିଲା ଯେମିତି କି ଏଇ question ଟା ठीक अछि, ତ ଆମକୁ ଭାବିବା ପାଇଁ ପଡିବ आ भितर कोटा हे पारे ଆଉ ଆମକୁ ଏମିତି ବି ଲାଗିବ କି ଆଉ ଗୋଟେ ବି ଠିକ ଅଛି, ତ ଯୋଉଟା ବେଷ୍ଟ ହବ ओके मोस्ट अप्रोप्रिएट सेटा चूज करिवे. सो 45 स्पेशलाइज्ड एक्सपर्टाइज ऑफ दिस कोर्ट्स. ओके काहे ना ए जो कोर्ट्स उडा बेसिकली ओके जनरली स्पेशल डोमेन रो से माने थाई परंती राइट, बट मेन तार ताको ओवरराइड करूची द नीड फॉर सर्टेनिटी एंड स्टेबिलिटी इन दीज एरियाज ऑफ लॉ. Now come to 46. Okay, so 45 row B is the answer. Now come to 46. The distinction between judgments covered under section 35 and those covered under section 36 lies in their subject matter and legal effect, admissibility and evidentiary weight, the court's discretion in their application, the level of conclusiveness attached to them. So subject matter and legal effect. A will be the answer. 46. Then 47 question though. Section 37 of BSA, which deals with relevancy of judgments other than those mentioned in section 34, 35, 36, is primarily aimed at excluding all prior judgments from being considered as evidence, limiting the admissibility of judgments to those directly relevant to facts in issue or other provisions of BSA, granting the court absolute discretion in determining the relevance of any judgment, ensuring that only final judgments are admissible in court proceedings. Okay, so limiting the admissibility of judgments to those directly relevant to the facts in issue or other provisions of BSA. Okay, so that is 47. 48 question though. The provision in section 38 allowing parties to challenge the validity of relevant judgments is rooted in the principle of principles pacharla, judicial infallibility, due process and fairness, encouraging appeals in all cases, promoting the relitigation of issues. So B is the answer, due process and fairness. Okay, taku promote korabo. Next 49, the fundamental principle behind the admissibility of expert opinion, okay, section 39, is the recognition that expert opinion are always superior to other opinions of evidence. The court must rely solely on expert evidence in all matters. Specialized knowledge can assist the court in understanding complex issues. Expert opinions are irrefutable and binding on the court. Okay, C will be the answer. Specialized knowledge can assist the court in understanding complex issues. So 49 row C will be the answer. Now come to the last question, question 50. The requirement in section 39 that experts be specially skilled in their field serves to create a hierarchy of experts based on their qualifications, limit the admissibility of expert evidence to specific fields, ensure the reliability and credibility of expert opinion, or to exclude opinion based on practical experience. So C would be the answer, ensure the reliability and credibility of expert opinion. Okay, so it is mainly about 21 to 40. Okay, this is basically 21 to 40. So Kali same means 21 to 40, but mains. Okay, so around I guess 5 or 6 questions will be there, including problem based questions. Okay, so जेहेतु हमें level 1 problem based questions उड़ाई करचु केवल level 1 problem based questions पढ़िबो, level 2 level 3 सेटा जेतल मु पढ़ाई सारी level 2 level 3 problem based questions सेतबेले पकेबी. Okay, so only level 1 problem based questions पढ़िबो. So 6 questions, if there are 6 questions, 4 will be theoretical. Okay, dita बहुत simple थिबो, dita टिके analytical थिबो और dita problem based थिबो. 6टा question आपन रहइबो. Okay, so which you will complete in 1 hour, then we will have a discussion on. And केमिति हमें prepare करिबा generally any competitive exam जोटी कि written paper अछि कि एटा तो प्री कथा हम कहउछु. So आपण जेति की section सारुचंती, ओके तार सेति की रो MCQs previous year questions both pre and main सेटा solve कर देबो तो ता पे एबे सब बही मिलुची मे बी सॉल्व नथिबो बट अनसॉल्वड अछि मेंस पे स्पेशली तो सिंगल रो अनसॉल्वड क्वेश्चन रो गोटे पूरा ग्रीन कलर रो बुकटा मिलुची एटा 20 वर्ष रु जत्ते जुडिशियल सर्विस परीक्षा अछि सेक्शन वाइज चैप्टर वाइज सेटा दे देछि ओके सो सपोज आपनकर सेक्शन 1 टू सेक्शन 30 ता भितरे लास्ट 20 वर्ष रे एई परीक्षा रे एया क्वेश्चन पड़छ मु जदि सेइगुडा कंप्लीट कर दोची ता बाहरु पढिबार संभावना किछि नाही ओके किंतु ता पई टिके ना टाइम होराइजन दरकार एंति नाही मु 3 मास रे साथ दे करी इट टेक्स 1 ईयर प्लस हमकु नॉर्मल बेयर एक्ट और जनरल कांसेप्ट बुझिया पे वर्ष खंड लागि जाउची तेनु एटा बहुत गुडे क्वेश्चन थियो ठीक अछि तो माने आ ता बाहरु प्राय क्वेश्चन पडियो बोली माने नाही ओके so सेटा that book you can get and once you finish a particular chapter or a set of sections सेटा ताकू यूज कर परे सिंगल रो सेटा ओके मु ग्रुप रे दे देबी मु थरे देइतिली सेटा अनसॉल्वड ओके सॉल्वड एंड कोन होबो सेटा 3-4 वर्ष रे देइथियो कारण सॉल्यूशन बहुत पेज पड़ेबो एत बहिटा ही एते मोटा अनसॉल्वड है ठीक अछि तो ताकू हम सॉल्व करिवो सो इट टेक्स अराउंड 1 ईयर खंडे लागि जो हम सब सॉल्व करिया कारण से माने गोटे गोटे पार्ट पई बहुत गुडे देइथियो ओके so that is the best way to prepare अपन नीचे पड़े स्पेशली जो माने सेल्फ स्टडी करचंदी इंस्टीट्यूशनल सपोर्ट नो नाहंती कि ताको रिक्वायरमेंट नाही ताले बेस्ट जिंस हला अपन गोटे जिंस सारी देबे एतिगडा सेक्शन तापर प्रीवियस ईयर क्वेश्चंस तार सेगुडा बोथ प्री ओ मेंस देखि देबे देन सेटा यू आर कंप्लीटली प्रिपेयर्ड तापर एटले एग्जाम आसी जिवो पाखरे तो सेते बेले अपन टेस्ट करिका सेगुडा सब दे पारे ओके राइट सो विल स्टॉप हियर देन तो काली हम डिस्कस करिबा सेम सेक्शन 21 टू 40 बट मेंस ओके मेंस रो क्वेश्चन होला कुडा हां मु सेटा देइथिलि म आउथरे पठे देबी ओके आउथरे पठे देबी मेंस रो अनसॉल्व माने ओनली क्वेश्चंस देइथिबो सॉल्व तो हम करिबा ठीक अछि तो जो नोट्स उडा मु दउची कि डिक्टेट करूची से सेही थरे ही सब सॉल्यूशन अछि किंतु क्वेश्चन उडा हमको जानिया दरकार से क्वेश्चन नहीं एते मोटा होई तो तार सॉल्यूशन जदि हो मते 5-6 वॉल्यूम हे जो ताको सॉल्व करू राइट so only the questions are necessary for us हमें से questions मिलले हम तार क्लास रे ही सॉल्यूशन कर दे पारे टेक अ ब्रेक ओके ब्रेक नियंतु एबे तो बीएसए रो ये करन ठीक अछि हम जोटा देइछि आपन को हमें 2014 पर्यंत इंग्लिश रो माने 2012 13 14 इंग्लिश एसेस सब गुडा डिस्कस करथलो ओके तो आज 2015 रो इंग्लिश एसेस गुडा 6टा एसे देइछि ओके दैट वी विल डिस्कस तो तार प्रिंटेड मटेरियल टा अछि आपन पाखरे ठीक अछि टेक ब्रेक फॉर 10 मिनिट्स देन वी विल रिज्यूम okay online students you can take a break for 10 minutes and then we will resume